welcome to this FedSoc Forum webinar call. Today, October 15th, 2025, we're delighted to host a discussion titled A More Perfect Union, States Double Down on Antitrust. My name is Kayla Kleist, and I'm Deputy Director of Practice Groups here at the Federalist Society. As always, please note that all expressions of opinion are those of the experts on today's program, as the Federalist Society takes no position on particular legal or public policy issues. Now, in the interest of time, we will keep our introductions of our guest today brief, certainly more brief than their careers would deserve, so I highly recommend that if you're interested, you check out their impressive full bios at fedsoc.org. I'll go ahead and introduce our moderator, and then I'll leave it to him to introduce our panel. Today, we're delighted to have with us Adam Biegel, who is co-chair of Alston & Bird's Litigation and Trial Practice Group and former co-chair of its antitrust team. Mr. Biegel joined Alston & Bird in 1998 and has been a partner since 2006. A substantial experience representing clients on antitrust counseling and litigation matters, including those involving government and internal investigation, mergers and joint ventures, pricing and distribution, compliance counseling and training, pre-merger reviews under the HSR Act, and multi-district litigation. And I will leave it there. A last note before I get off your screens, if you have any questions, please do submit those via the question and answer feature, likely found at the bottom of your Zoom screen. So they'll be accessible when we get to that portion of today's webinar. I'll ask that all questions submitted there, A, pertain to this discussion, and B, end with a question mark. With that, thank you all for joining us today. Mr. Biegel, the floor is yours.
Great. Thank you very much, Kayla, and thanks to the Federalist Society and the Antitrust and Consumer Protection Practice Group for sponsoring today's discussion. I wanted to tee up the topic and then also briefly introduce our panelists, as Kayla said. First, to tee it up, many antitrust lawyers spend a lot of their time focusing on federal antitrust law, with occasionally only a passing glance to what's going on in the states and the state capitals. They know that there are state antitrust laws. They know there are some slight divergences, whether it be on mergers or conduct activity or litigation standing, FTC acts. But from over the years, there are periods where it has not been a large focus for the antitrust bar to focus on what is going on in the states. That has changed a little bit, or a lot, as we're going to discuss today. In recent years, we have two states, Colorado and Washington, that have enacted their own merger regimes, their merger filing regimes, after discussion of uniform merger filing laws that we're going to discuss today were pushed out to the states, model legislation, and at least 5 other states are considering merger filing laws in their legislatures. There are a number of states also thinking about broadening their antitrust laws, including New York and California. And there are a lot of attorneys general, whether Republican or Democratic, who are viewing antitrust as a very popular topic for expanded antitrust enforcement. Literally, our panelists here today, we've been emailing over the past few weeks, even since this program was announced. And literally by the day, we are seeing legislative developments coming out of state capitals, including some that we're going to talk about today that actually occurred just within the past 24 hours in connection with a merger. So what we wanted to discuss today is what should practitioners and people who care about antitrust policy and antitrust enforcement know about what is going on with the states today and what is likely coming down the pike from state capitals going forward that could change how people advise companies and how companies act based on the expanded role of states in antitrust enforcement. So today, I think we have a wonderful panel to discuss exactly these topics, people who are not only experienced working in state capitals, but are also thought leaders on these topics. So going alphabetically, I'll give a very brief introduction who we have with us. First, Gwendolyn Cooley. Gwendolyn spent almost 20 years in the Wisconsin Attorney General's office as the Assistant Attorney General in charge of antitrust, and also served a term as the chair of the Antitrust Task Force of the National Association of Attorneys General. She is now practicing with the firm of Lindsay Cooley Law, consulting on mergers, state AG issues, and other policy matters, and also has founded a company called TAMET that uses artificial intelligence to help predict some enforcement trends in the antitrust area. And she also hosts a pretty cool podcast, Antitrust 101. So very, very well-rounded in a lot of the topics we're going to talk about today. Similarly, Rahul, a partner with White & Case in Washington, has served both at the federal and state level in antitrust enforcement. He was the General in the Antitrust Division of the Washington State Attorney's General Office, and he was also deputy director of the Federal Trade Commission's Bureau of Competition in Washington. So welcome, Rahul. Last but not least, Eric Stock, who is a partner, and he is also a partner White and Case in Washington, as I should not fail to mention as well. Eric Stock is a partner at Gibson Dunn in New York, practicing in the area of antitrust law, and he served for 3 years as the chief of the Antitrust Bureau in the New York Attorney's General Office. Also has been involved in the Uniform Law Commission that I mentioned a moment ago, and also is the author of a recent article in Antitrust Magazine on precisely this topic about state antitrust enforcement and its pros and cons. So with those introductions of our thought leaders who are on our panel today, I wanted to tee it off by just jumping right into some of those merger topics and look to Rahul to tell us a little bit more about why we're seeing this activity of states becoming interested in merger control, which, for many years has largely from a filing perspective been a federal enforcement priority and a federal issue. Rahul, would you mind sort of bringing us up to speed on that change dynamic?
Yeah, well, I think there's a couple of threads to disentangle really quickly, right? Like it's not necessarily the case that states are more interested in mergers writ large, right? I think states have always been interested in mergers that may have an anti-competitive effect, especially ones that affect, disproportionately may affect their local communities. What we're seeing that's changing though is on the notification front, is on methods of detecting mergers and getting involved in merger review. And I think that's what you're getting at. So historically, states have relied on the federal agencies to loop them in on HSR reportable transactions. And I think for the most part, that worked fine. But that said, there were two, I think from the state's perspective, big deficiencies in this process that they are now reacting to in different ways. Now, the first deficiency is that merger review moves at a very fast clip. You have an initial 30-day waiting period, and there can be a long lag between when HSR is filed and when a state AG even learns about a transaction, especially if it's a non-public transaction. That delay stemmed for a number of reasons. Like one is, pretty benign in that it just sometimes takes time for the federal agencies to, wrap their arms around a transaction and even get a base understanding of a deal before identifying who may or may not be affected, and then looping those states in, right? So that takes time, but that eats into that 30-day initial waiting period. More recently, though, this delay has been further exacerbated by what states see as an increased reluctance, I would say, of parties to grant waivers. For the federal agencies to share certain information, certain non-public information, they need waivers from the parties. And for reasons that vary among parties, the states have felt that those waivers are not coming as quickly as they would like, and that there may be some gamesmanship there. And so that added to what was already a normal process delay of the federal agencies just doing an initial review and then looping states in. And like I said, this is a 30-day window. And so that's every day is significant. So by the time, like under the current regime, I would say by the time a state gets up to speed, the window to have meaningful input before a second request can sometimes be very minimal, if anything at all. The second deficiency I think states are reacting to is the HSR threshold itself, right? Like right now it's about 120 million. That's a pretty large transaction, right? It misses a whole swath of deals with highly local effects that are just smaller than $120 million. So think, hospitals merging in mid-sized markets, or physician acquisitions or roll-ups. Those transactions might never trigger federal reporting. But for those local communities, they can radically reshape those markets, especially if they're markets that are very consumer facing and that are ones that as an elected state AG would be highly sensitive to, like healthcare markets. And so state AGs feel like they're under a lot of pressure to respond to that. And so because of those two gaps, I think we're seeing two different flavors of state merger notification laws that have been popping up over the last decade plus, right? This is a trend. This is a trend that's been in progress for a while. One flavor of these notification laws targets sub HSR transactions, and these tend to be industry focused, and I think almost all of them are healthcare focused, right? It can include hospitals, physicians, nursing, and even pharmacy related transactions. The other one that we are seeing more recently that you touched on is broader. This I think is a direct reaction to states feeling that parties are engaging in games with withholding waivers. And so the Uniform Law Commission Project has put together this uniform law that obligates parties to give state AGs copies of the HSR filing if there are some material connection to the states. Think, are they headquartered there, or is there a certain amount of transaction happening in the states? Washington and Colorado have already passed these laws, and both laws are in effect in both states. But there are a handful of other states that are actively considering it, and I highly suspect will also pass it. And so what we're seeing right now, and I'm gonna wrap this up, but what we're seeing is states trying to close these two gaps at once. Timing and visibility into HSR deals and oversight of sub HSR transactions with local impact. Both approaches reflect a shift towards states wanting a more formal seat at the merger review table, right? They don't want to be bystanders waiting for review. They want a guaranteed opportunity and shot at shaping and participating in the review process.
Adam,
Adam, you're on mute.
The mic down. Gwendolyn, so what does that mean practically? What you're seeing with the burdens, the efficiencies, the timing of how compliance-oriented companies can work in this new world?
So I think the very first thing, Rahul talked about how there's kind of two buckets of types of statutes. The first thing is to assess kind of what kind of transaction do I have? Am I a person with presence in, and I use the Supreme Court version of person, a person, aka company, with presence in Colorado and Washington, or am I a person that is a healthcare company and I'm in Minnesota, or I'm in Oregon, or I'm a fuel oil company in Maine? Okay, so where's my presence, and kind of what is my scope in that state? A lot of the states have a threshold of are you doing business in that state to the equivalent of 20% of the current HSR threshold, right? So if the current threshold is $126.4 million, I'm not gonna do that math off the top of my head, but let's just say that that's like 22-ish. Yeah, we'll go with that. $22-ish million in that state, okay? So do you meet that threshold? So really, it's going to take a little bit more time to just do the analysis up front before you're filing HSR, because one of the other considerations that practitioners need to remember is that some of these state notification statutes require a contemporaneous filing, and that can mean same day, right? It seems like Washington's statute, or Washington's merger notification statute, requires that kind of same day filing, and what does that look like? Practically speaking, it is not as simple as what everyone is used to filing HSR, right? You're going to have to learn different procedures in the same way that you have to, if you have an international company, have different procedures for filing with the CMA or with DG Comp or with South Africa, right? Okay, so you're going to actually need to have a little bit of specialization. The procedures vary state by state. For right now, in Washington state, you send an email to a specific email address with your merger filing. In Colorado, you have what is, I say with great respect to my friends in Colorado, it's like a jot form, right, that you have to fill out. It's kind of adorable, right? So these are not it's early days. And what I suspect will happen is that one of the states will figure out kind of the best way to do it, the way that's the most efficient, the way that gives them the information the cleanest and the best that they can search it and actually use it. And then the other states will follow that, because right now we're in a information asymmetry. We're at the cutting edge. How do we handle this situation? And it's not quite clear yet. As for timing, some of the proposals that have come forth do not require the parties to essentially stop the transaction and wait for the state review. And some of the proposals do require that to stop, particularly related to healthcare. And part of the reason for that is that state AGs wear multiple hats. And so some of the things that they're concerned about in healthcare are things like, is this merger going to result in the closing of a hospital that is going to make people not able to get maternity care or something like that, right? So they really want to make sure that these other kind of public interest factors that go beyond just antitrust are thought about. Is this going to be clunky? Absolutely, right? Part of the reason for that clunkiness is some states, the Uniform Law Commission, when it put out its recommended statute, it actually contains a provision that you cannot have filing fees for the transactions. And in Colorado, for example, that is in the statute. And so the Colorado State Legislature, in order to deal with that, appropriated $68,000 to the Colorado Attorney General's office to handle these incoming transactions. $68,000. It's wonderful that the state legislature appropriated anything, because I suspect that will not always be the case. But $68,000 ain't buying you an attorney, right? That's going to buy you maybe a 0.5 FTE paralegal and maybe some software to analyze those. So you kind of get what you pay for. And with $68,000 rate, that makes it a little bit clunkier for practitioners. There isn't going to be something smooth. One of the ideas that was floated was from the Uniform Law Commission that there would be kind of a central filing place, and then you could just stick your merger filing in there, and then the states would pull from that. That hasn't quite come to fruition because there's not enough states that to spread the pain around on having a system like that. So early days, and yeah, it's kind of clunky right now.
Thank you, Gwendolyn. I think that helps with the what, and Rahul explained a little bit about the why. Eric, can you talk to us a little bit about how this makes sense and whether it promotes? I know you've in that article I mentioned have and your involvement with the Uniform Law Commission have had some thoughts about this. Let's take a step back and if you want to give us a few comments about your perspective on what this means for overall antitrust enforcement. And we'll allow other panelists any other comments they want in response to that too. This is a very live topic.
Thanks, Adam. So let me split that into two parts. I think one is a generalized question: should states be involved in merger review at all? And the second question is specifically the state statutes. What are the plus and minuses of those? And I'll just briefly comment on it and then welcome the debate. But on the pro side, in terms of getting states involved in merger enforcement, you have all the arguments for state enforcement generally. A class action law firm gets to challenge a merger if they find one consumer who they would like to claim was harmed by the merger. So why shouldn't the sovereign attorney general of the state of California have that same right? So that would be one argument for state enforcement. We have a system of multiple sovereigns and multiple levels of antitrust enforcement. You can violate federal and state statutes. On the not so pro side, there is something unique about merger enforcement where I think there is a case that the state's involvement is not as productive. And that is that the merger enforcement, to the extent it's part of the Hart-Scott-Rodino process is a very condensed, expedited timeline that holds up virtually every deal until there's a decision or a compliance by the parties with the, a second request or the other requirements in the waiting period. And this is a very specialized, expedited process where even at the federal level, we don't want multiple enforcers. We have a clearance process between FTC and DOJ. And for example, Europe has a sophisticated system of determining whether member states or the European Commission should be involved. What sane person would design a system where every state and including a federal agency kind of gets to look at a merger before the parties can even close the transaction? That doesn't seem like an efficient review process that you would design if you were starting from scratch. So I think there is a case that can be made that state enforcement in the pre-merger challenge context is kind of less efficient, less justifiable than state involvement in other antitrust matters. But you could debate the topic, and I'm happy to. In terms of this state statute, I just want to comment on kind of how we got here, because I did have some involvement with the ULC process. There were a lot of state statutes that were being proposed for passage that would require mini HSR filings, mini filings in different states. And the industry was looking at the possibility of some very challenging situations. So for example, if each state adopted a different standard for a new state pre-merger filing, there could be 50 different standards that had to be applied together with, dozens, if not hundreds of foreign standards for antitrust filings. There could be the need for an entirely new form to be drafted for each state. There could have been a waiting period, as I think Gwendolyn mentioned. These mini HSR acts that have been passed under the ULC do not have a waiting period. They are only provide for sharing of the Hart-Scott-Rodino Act and no state authorized ability to hold up a transaction. Some of the state statutes, including the New York statute, also they required a filing even without any demonstration that the transaction had any impact in the state. We also face the risk of state pre-merger filings with inadequate confidentiality protections. So that was kind of the risk that was posed by a lot of these individual state statutes that were being considered. And so I think that what came out of the ULC was kind of a compromise to kind of, make it unnecessary for states to have their own individual pre-merger laws, and also provide a mechanism for states to get early access to the filings that are filed with the federal authorities to kind of jumpstart their investigations. And it really created a compromise. We don't have 50 different standards. If the ULC language is followed, it's the same standard in each state. It's no new form. It's just the HSR form that gets sent around. There's a link to each state to require filing, either a headquarters or 20% threshold that is met relating to the transaction has to relate to the state in some way. There's more robust confidentiality protections, and the states get access to the HSR without a waiver, without the parties having to submit a waiver, and there's more confidentiality protections that are built into that. So this is the compromise that emerged. I'm sure that some people on both sides will think it's inadequate for their purposes. And again, happy to discuss that, but it really does represent a compromise between the concerns that I think a lot of us had with the individual state laws and the concerns that many people have with state review at all of kind of national level transactions. Why don't I stop there? I'm happy to get into some of the points I made in my article about state enforcement if we get there, but that kind of gives you an overall sense of kind of the factors in play, both in terms of the wisdom of state enforcement and the wisdom of these particular notification statutes.
No, thank you. Would any of the panelists like to tackle this? We can also bring this up in the excuse me, in the context of the conduct divergence too, about whether the laboratories of democracy are serving our ends. Why don't I actually reserve that a little bit until we get into the conduct discussion, because I don't want to take up too much merger time or time with this merger discussion, but I did want to sort of have an exit from some of this merger discussion by maybe asking Rahul to maybe make a prediction for us about what this practically is going to lead to, with those gaps being filled, as you were talking about, in terms of more state standalone enforcement, because I think we've all seen, parallel enforcement, states and the federal agencies partnering in bringing actions, but we've also seen over the years some divergence where the federal government didn't do something and state attorneys general did. And I think anytime there is a variety of distinguished leaders like state attorneys general and some of the people heading the antitrust agencies, there can be differences of opinion. And so especially, if there might be accusations of under enforcement or, inconsistent enforcement, states may try to, or state AGs might try to fill the gap. So Rahul, what do you think this is going to lead to in terms of enforcement trends? And feel free to mention the case I know I was referring to earlier, where we may very well have an example of those, on our hands with a pending merger review.
Yeah,
Or
no,
two.
it's a really good question, and one that I have a bit of a nuanced thought on it. And this is, curious if anyone else on the panel may have a different opinion on this than I do. So I personally do not think that the uniform law, right, the one that requires copies of HSR materials, I don't think that law by itself is going to increase the number of states who are going to be challenging mergers, either on their own or in contrast to what the federal agency may not be doing. Now, but I want to be nuanced about this, because I think that we have been seeing a trend for a while now of states being more and more active in merger cases, right? So this is just not even that long ago, T-Mobile Sprint, the states challenged that and the DOJ didn't. Kroger Albertsons was another variation. The FTC and a coalition of states did challenge that, but 2 states filed their own parallel action in their own courts on that. And then today, we see a coalition led by Colorado and a number of other states seek to intervene in the HPE Juniper Tuniak review, saying that DOJ settlement is inadequate. Now, I think that this trend has been going, the momentum has been building, the momentum is there, and this uniform law that we're seeing is evidence of that momentum. It in and of itself is not pushing things forward, but it is illustrative of this trend that's already been in effect and that is going to continue. So this is maybe the too lawyerly nuance here is I think we will continue to see states being more and more active in merger review, both going on their own, maybe playing a more active role in joint federal investigations, or maybe a challenging one that the federal agencies do not see as problematic for whatever reason. I think we will see that. I don't think this law creates that momentum. I think these laws are evidence of that pre-existing momentum. So that's the little nuance I see.
I appreciate that. Let me turn the discussion a little bit back toward conduct. We as antitrust lawyers know that while mergers are important, merger enforcement is important, the vast majority of companies are not necessarily engaging in M&A activity on any given day, but they are involved in conduct in hiring employees, developing new products, coming up with joint ventures, distributing their products, things that where antitrust law is implicated, how they do it and what the guardrails are. Eric, could you talk to us a little bit about the role of the states in sort of jumping into the fray of antitrust enforcement on those conduct issues? whether it's, no poach enforcement or collusive activity, just to sort of level set, how companies have been thinking about complying with federal law and applicable state law before we get into maybe any of the changed horizons.
Yeah, thanks, Adam. It's a great question, and I do think that the proponents of state antitrust enforcement have a stronger argument for active state enforcement in the area of conduct, where you don't have this condensed pre-merger filing system that kind of makes it hard to have a lot of multiple levels of enforcement. In the conduct area, I think what most commentators would agree is that the states are kind of at the strength in terms of the strongest in terms of their legitimacy when we're talking about local matters. And by local, I don't mean, street by street, but, a large hospital merger in a major state. I don't think there's a lot of people that dispute that state antitrust enforcement is legitimate and important and effective in reviewing hospital mergers within a state. When I was at the New York Attorney General, we had a case against New York City tour bus merger. These are cases where the states have the strongest claim to legitimacy and the value that they bring by knowing their local markets is at its highest. So I certainly am a proponent of the states having the right to take action there. I think where you see more controversy is where you see a state trying to influence competition kind of at the national level. Transactions or conduct, let's say by big tech companies that are really national in scope. That's where it's more controversial. Now, you do still have a situation where, like I said earlier, private plaintiffs can bring cases against those defendants. So why not a state? I think there's a lot of pluses and minuses. I'll tell you what, something I believe that I put in my article, which I'm happy to share with anyone, is that what I think is important is that when states seek to influence conduct, not at the local level, not in a case about New York City or healthcare in Minnesota, but when you're talking about, let's say, something based on the internet, something that can't really be addressed on a state-by-state matter, state-by-state basis, I think it's important that when states take action, they do it under federal law. So not everyone is aware of this, but there is a federal statute that provides that states do have authority to represent consumers in their states on national antitrust matters and to bring cases in federal court. The states also have authority to bring cases in federal court when they act as a purchaser, and they very often do so. And so putting aside whether a state should or should not act in a particular case, what I think is very valuable, it brings legitimacy to the action, at least more legitimacy, and it also creates an enforcement environment that the business community can address on a holistic basis, not on a state-by-state basis. If a case is brought in federal court by either one state or a group of states, then the decision as to whether that conduct is lawful can be addressed in a federal court. It can go up to the circuit. It can even go to the Supreme Court. And it'll be more effective because it'll make a new national rule. And it'll not just affect that particular situation, that particular example of conduct, but it will have a nationally important binding precedent. And so that kind of case will be more effective. And I think it's fairer in terms of our democracy. I think it's not necessarily fair for one single state to try to substitute its policy views of how the antitrust laws should be interpreted by bringing a case under state law decided by a local state judge under a law that the local community in that state have determined is the right way to organize competition in that state. Why should one state's electorate and judicial system be able to decide how the national economy functions. That seems that at least there's a bigger question of legitimacy there than when you have a state bring, a state attorney general's office bring kind of a cutting edge case, but they brought it in the District of DC and it's appealable to the DC Circuit and to the Supreme Court. So in my opinion, states are, very well positioned to bring local cases, to bring cases that affect primarily their state under both federal and state law. And then they're also in a position when they believe there's a need to address a national economic problem, I think they should exercise their discretion to bring cases under federal law and federal court. And by the way, that's what states generally do in probably 90% of the cases, I would say.
I know, Gwendolyn, before turning to your sort of survey of what's coming down the pike from states, I know you have some thoughts on some of the things Eric just said that I'd tabled until now. So I guess from your, you all have state perspectives, but I know in particular you have some perspective about what we often call the laboratories of democracy. How would you react to Eric's comment about the sort of diversity of things that states can do in both conducts and mergers to alter business conduct?
Yeah, well, my first thing I would say is Eric asks, what sane person would design a system this way? And I will just note, our founding fathers are literally the ones who designed the system this way. That's what federalism is all about, right? So that said, right, there are wonderful complements in state and federal antitrust enforcement. States and federal governments have historically really worked well together. They do, as Eric says, often bring the cases together under federal law, but sometimes federal law is not enough, right? Sometimes federal law doesn't address a thing that a state legislature thinks is important. And so that's why you do end up seeing so many state antitrust related laws, especially in the last 5 years. And they kind of fall into a bunch of different buckets. Let's talk first. I think there's some boring procedural stuff. A lot of antitrust statutes have been updated. And it's not just a kind of red state, blue state thing. It is actually pretty across the board. We see antitrust procedural updates. Indiana has passed a comprehensive antitrust update that enhances penalty amounts and makes more people available for antitrust enforcement. Tennessee passed a statute that prohibits collateral discovery on state agencies when a state AG brings a case. So, right, that's a pretty big deal. California's statute that just got signed into law in the last week or whatever, a couple days ago, I think actually, added civil penalties for up to $1 million. So that's also a big deal. Those are boring procedural stuff. There's also some kind of more unique things. Eric is a big fan of the 21st Century Act that New York considered a few years ago. I say that obviously sarcastically. California has a law review commission that's right now kind of essentially doing a forensic review of its antitrust statute. And they have kicked the tires a number of things. They considered the merger filing, but it sounds like that's gone down. And so that won't be passed. But they are even looking at things as somewhat specific as cross-market efficiencies to justify conduct, ostensibly in response to the Google search case. So they are definitely right at the cutting edge of antitrust enforcement. But there's a piece of statutory framework that the state AGs are really concerned about that has some national impacts, but really is much more local. And that is kind of algorithmic pricing and essentially anything related to housing, right? You see kind of two separate kinds of cases. You've got a lot of cases related to like real page and price fixing, alleged price fixing amongst rental companies. And are they using it through this software? And then you also see the recent case against Zillow and Redfin, alleging that they were conspiring also to kind of fix the price of stop competing for the sale of rental housing advertisements. So again, you're seeing real concerns about that. And so state legislatures have actually passed a ton of statutes. 75 bills have passed as of this August related to price fixing and algorithms. And I will note, Adam, I think might have seen, I get really tetchy about people saying the word algorithm because of my tech background, but I will just say they're using that term in kind of an inaccurate general way to say basically anything related to computers, any kind of price fixing, what Maureen Olhausen has called Bob statutes, essentially, right? So if Bob can do it, or Bob can't do it rather, then neither can the algorithm. So there's a lot of state statutes related to that. California passed one that says essentially using a common pricing algorithm under California law for pricing rental housing illegal, right? There's a lot of those kinds of statutes that are also related to what is essentially category discrimination, like discrimination on the basis of race or gender or something like that. So a big tranche of statutes related to that. In artificial intelligence, Colorado has one that's pretty famous. And then some statutes really just prohibit those algorithms. Not statutes, bills prohibit that kind of algorithmic usage at all. Those I think would be harder to pass since those kinds of things are everywhere. But anyway, so those are kind of really a bunch of the key buckets of types of statutes that we see in the state legislatures across the country.
So Rahul, from your perspective, I'd be curious, where do you think is going to catch on? Because we've seen sort of waves over time, whether it's banning non-competes, banning MFNs, Illinois brick repealers, things that are not just ideas, but they become trends in the state capitals that lead to those pockets of divergence that you can't ignore. Are you some of those areas that Gwendolyn was talking about, like the algorithmic, pricing bans? Are those sort of the flavor of the year, flavor of the month that we think are going to really be changing what is the law that we all have to be paying attention to, or is it a flash in the pan?
It's a good and dynamic question, I think, right? Because I think first of all, like we take a step back, and you've heard this from Gwendolyn and Eric, is like we've always had some differences and divergence between federal and state antitrust law, right? Like resale price maintenance is still per se illegal in several states. There are baby FTC acts that have long allowed broader unfair methods of competition claims than what the FTC historically has said. But what feels different now, I think, is that we're seeing a number of states exploring even bigger departures, right? You have a handful of states that are very seriously flirting with an EU-style abuse of dominance standard. We're also seeing a lot of activity around labor, right? I think this is the one that's the most salient because it so touches the wallets and pocketbooks of the constituency, right? So this is activity on no-poach agreements and non-competes. And then now algorithmic collusion, right? AI and algorithmic collusion, especially when it affects things like housing and rentals. But we're also seeing activity in pharmacy, right? Because drug prices people feel drug prices are out of control. And so we're seeing states take aggressive action against, PBMs, for example, right? Like Arkansas, this wasn't an antitrust law, but it was cloth in anti-competitive terms. But, Arkansas it attempted to passed a law. I think it's put on hold, but prohibiting joint PBM pharmacy ownership, basically breaking up that vertical relationship. And so we're seeing a lot of activity in these areas where the harm is felt in a very consumer-facing front, and things that I would call like kitchen table issues, dining table issues. Adding to that, you're seeing a lot of states, Gwendolyn talked about this too, like pass, increased penalties and and other fees. And so they're framing this as a, in deterrence language, right? Like where it's going to be expensive to break the law in our state. And so I think you're going to see a lot of those pass, right? Like there's 50 states, not all 50 are going to, well, there's 50 states plus the jurisdiction, so 53 jurisdictions total. Not all the states are going to pass everything, but you're going to see a sizable portion pass more laws that are on hospital transactions, on labor, on non-competes. No poach has already been per se illegal, but you may see more activity there. Algorithmic collusion in housing, right? I think all of those things will pass. Now, the question is, like when I say it's dynamic, is passing is just one step of the process, right? It then comes the challenges, right? It's whether they survive after they pass. But putting that second question aside, I think like the immediate impact, I think is twofold. One, like companies right now, as this landscape is shifting across the states, they're going to be facing a significantly more complex compliance patchwork, right? Their internal controls are going to have to be so much more robust at this point. And the other thing that's the other impact is that state AGs now with these bigger penalties, more expansive laws, they're going to have leverage to bring novel cases and to extract concessions and settlements. And we saw this. My old boss, like this was when I was at the Washington AGs, like brought a series of actions on franchise no poach agreements, the effect of which was national. And so that dynamic exists whether or not these laws eventually get challenged or overturned or paused or whatever. Some of the more aggressive concepts that we're seeing, definitely algorithmic collusion, things on AI, abuse of dominance, they will very likely be challenged. They will draw preemption challenges, dormant commerce clause challenges. But even as those play out, it's going to create real uncertainty that companies just simply like they can't ignore. So, I mean, I think to sum it all up, right, I think the state's role in conduct enforcement is shifting from a handful of what I would have called technical divergences into something that's more of a laboratory for bold new doctrines. And what's really interesting is that this patchwork may well become the proving ground for the next generation of antitrust that's adopted at a federal level, right? I mean, if you look at the non-compete rule, that did look at how states had approached this issue and tried to cannibalize what at least that FTC thought worked best and what didn't. So the beauty and messiness of federalism at work.
Thank you, Rahul. I think that leads into something I did want to bring up, a couple of overarching topics to kick off, and we are going to leave some time for questions. I know we've got a couple that I've got in the queue. Gwendolyn, you made some observations, like when you left the NAAG task force, about what's going on in the American body politic that makes antitrust more relevant and interesting. I guess how do you assess why we're seeing more of this sort of political, not in a negative way, but just coming out of political bodies in the state capitals, more interest in utilizing and taking a look at antitrust laws? What's going on in our country that makes antitrust more interesting and relevant?
I think this trend has been accelerating in the last almost 15 years, certainly, because antitrust is such a specific tool, and it's a tool that the attorneys general can come together on because they agree on the ends, right? What they want is to be able to exercise political power over a large company that they think is doing something wrong, right? I think what's different that we see now is essentially a split between the traditional antitrust, both kind of slightly more pro-enforcement and slightly more pro-business, kind of what we now call centrists, although at the time they felt very miles apart from each other. And then now we contrast that with what is so weirdly MAGA and Lena Khan populism at the same time, right? But those are very different things, and that it's kind of an approach that I can actually describe best with an example. So one of the really great examples of kind of that that first bucket of that pro-enforcement, but acknowledging that business has an important role to play is kind of that Spitzer multifactorial approach. I was teasing Eric earlier, and so now I'm going to give him a compliment that he was instrumental in one of the most important cases that the state AGs have ever brought, which was New York versus activists. That was the Nemenda case in the pharma sector. I mean, that case set the stage for states, right? And that really allowed states to provide value, because states are such big purchasers of drugs, on a specific area of, in this case, product tapping. And so that was an example of really that kind of very specific approach, right? We want you to innovate. We want you to have drugs on the market. You just can't have shenanigans, okay? Versus the con MAGA group of folks who think big is bad, and we need to be able to exercise power over those folks, because particularly when it comes to technology, unlike drugs, there isn't anyone to regulate those. All right, it's antitrust as the regulators. And you see that in Europe, where they have a DMA. The people who staff the agency that deals with the DMA, those are antitrust people, because those are the people who have the expertise to know how these tech companies operate. And so all of those groups now are kind of coming together to get a handle on how do we handle consolidation in America. And it's a really interesting time to unpack it all.
Thank you, Gwendolyn. I did want to, one of our audience members, I think, hit on one of the other topics I wanted to cover, and I think there's Rahul made an allusion to it. Happy to have him that or others. What are we going to see in the way of challenges to some aggressive state laws? Do we think we're going to see, I think as you were starting to mention, Rahul, dormant commerce clause challenges? I know, Eric, you wrote about that in your article too. Just because it's passed doesn't mean it's going to survive, as you were alluding to. So, is that something that's going to take another 5 to 10 years to play out? What do you see as the battleground or some of the guardrails in terms of challenges to aggressive state enforcement and legislation passing?
Yeah, no, I mean, I think this is, I wish I had a crystal ball here on this, right? But I think a lot of this is going to come down to the details of what the laws are trying to prohibit. Right now, a lot of them are really in embryonic bill form. But let's assume something, really aggressive and expansive. And I think those would be prime targets. I don't know, successful or not. I won't, put an index. I won't index that at all. But they're prime for challenges on, classic preemption issues, on dormant commerce clause. But as states keep pushing this envelope, let me put it this way, let's take a step back and think about, the states were reacting to what they saw as aggressive pushing on certain fronts, like, for example, with the waivers. And there was every force has an equal and opposite, reactive force. Are the states now courting a similar equal and opposite reactive force by pushing too far with state legislation that may motivate an otherwise dysfunctional Congress to act and cabin them in? I think that's a real risk here that the states are running. So I think we will see both legal challenges in the courts, as well as, lobbying efforts in Congress. For example, I think we have seen laws that are seeking to preempt states' rights to legislate on AI. How much further does that strategy go? So yes, there are challenges. There will be challenges. The states are inviting pushback. At the end of the day, it's going to be in the details, who is on the winning side of that.
Eric, I want to turn to you for another question that was raised by an audience member. Maybe, I don't know if this came up in the Uniform Law Commission. There's a question saying, in light of what Gwendolyn was saying about $68,000 to actually monitor and enforce a state merger law, is it within the realm of possibility, or was it discussed by the Uniform Law Commission that maybe there should be private rights of action or private attorneys general that could enforce compliance with these laws or take action? Obviously, there are federal abilities of individuals, as you referenced, to challenge mergers and other conduct, obviously under the federal laws. But was that envisioned, that we might want more private enforcement of some of these procedural laws, in addition to some of the substantive rights people have to really make people take them seriously, if state legislatures aren't going to give too much in the way of funding to monitor these laws?
Great question. I think it's important to kind of highlight that these mini HSR acts, as we often call them, pre-merger filings, it's a very unique system. It's to continue the debate with Gwendolyn. I mean, I'm not sure the founding fathers really thought of a pre-merger notification
Come
system.
on.
I think that individual consumers can bring lawsuits challenging deals. I mean, they can bring class actions challenging deals. They can bring private actions challenging deals. Competitors can do it too, and states and the federal government. I think what is unique about the HSR Act and the new ULC statutes is they provide they try to create a system for the expedited resolution of a pre-merger review before the deal closes. And by its very nature, that doesn't really accommodate a lot of fingers in the, a lot of chefs in that kitchen, shall we say. So no, there isn't a private right of action to get involved in the pre-merger notification process. And I don't think there should be. I think that there is only a limited amount of review, and it's important to keep it efficient to conduct pre-merger reviews of deals, because otherwise you're going to make deals impossible to proceed with, not because of merit or substance, but just because you'll have an unwieldy process. So look, I was at the state AG, and you can do post-consummation challenges. There's nothing wrong with a post-consummation challenge. They happen regularly. And the fact that an individual consumer or a competitor cannot participate in pre-merger review, and maybe the fact that some states should voluntarily forego from getting involved in purely national mergers at the pre-merger review process, that shouldn't necessarily, that shouldn't necessarily dictate who has the right to bring a post-consummation action. So that's my reaction to that.
Appreciate that. Since we're coming to the top of the hour and we want to respect everyone's time and close out at the top of the hour, I just wanted to open the floor to the panelists to maybe give us, a couple of seconds of maybe their final predictions about things that they think are coming down the pike, things that may surprise us, please us as advocates, or anything they wanted to add before we closed out at the top of the hour. And I'll go back to you, maybe Gwendolyn. I'll go to you first. Anything we should be on the lookout for? Do you think that's going to happen that we haven't already discussed?
Sure, and I would say that the thing that I would say is actually hopeful for America is that you're going to continue to see attorneys general working together in surprising ways, despite a political climate that seems so full of animosity. And we're already seeing that on the recent Redfin case. So that's at least a note of hopefulness for America.
Thanks. Rahul, how about you?
Yeah, I want to be respectful. I actually want to add to some things that Eric had just mentioned too in his last remarks. I mean, I think at least on the private right of action with respect to pre-merger notification, I'm going to say this as both a former enforcer, state and federal, and as someone who now represents parties filing HSRs. There's a lot of confidential, non-public information in there that none of those people, the enforcement community and the parties, do not want out in the public because they're competitively sensitive, right? So I think that in and of itself would caution against kind of like opening that up to significant private right of action. The other thing that I just want to flag for the group is I was recently at another antitrust conference in the Pacific Northwest that had representatives from Washington and Colorado, like the two states that had passed the baby HSR laws. And I think one of the things that they're recognizing is I don't think anyone fully understood the volume of HSR transactions that come through the door. And so, yes, in going into it blind, Colorado allocated the equivalent of one FTE, right? A 68,000. It was like, it was half an FTE, one FTE. I don't even know how much it is. I think as these two states are working through their kinks, there will be opportunities for them to go back to their legislatures and ask for appropriate budgeting based upon having a recognition of what the volume actually is going to be. And so the last thing that I want to just say really, really quickly, because we're at time, is we talk about the margins, about differences, but feds and states do work well together, and the feds often like the states working with them. It's a force multiplier effect. So I think I think the enforcement community as a whole is bullish on these developments.
Thank you. I know Kayla's coming back on, and we are over time. Eric, do you want any 10-second final words? If not, we'll turn it over to Kayla. I'll leave it to you, Eric.
No, I'll rest on the briefs. Thanks, Kayla.
All right. Now, I'd like to thank my panelists for excellent attending. Kayla, I'll turn it over to you for any final comments and closing it out.
Sounds good. I will echo those. Thanks. We really appreciate you all taking this section of your days and sharing your expertise and insight in what was a fabulous discussion. Thanks also to our audience for joining and participating. We welcome listener feedback by email at fedsocforums@fedsoc.org. And as always, keep an eye on our website and your emails for announcements about other upcoming virtual events. With that, thank you all for joining us today. We are adjourned.